the suggestion which fell from the court at the case management hearing which took place on 3rd July. I took that very seriously. I consulted my colleagues, and I am concentrating only on the State Reorganization Act because Article 370, I'm adopting the argument. My written submission also I've noted, I've adopted the arguments of Mr. Raju Ramachandran because they were available at that time, and of Mr. Gopal Shankar Narayan, the written submissions on 370 and the abrogation and all those aspects.
Now, Mr. Singh, can you just formulate what your submissions on the Reorganization Act are going to be? If you can just, we'll take it down.
They are broadly in my written submission, but there are some nuances and finer points which I have to, which I'll place before your lordship. Broadly, it is this, Mullah. First of all, the proclamation, the presidential proclamation of 19th December 2018, paragraph C2, Roman 2, is void. And that is the one by which the two provisos to Article 3 was suspended. The two provisos which applied to Jammu and Kashmir in Article 3 was suspended without even concomitantly applying the proviso which exists for the rest of India. That's number one. I'm just formulating the proposition.
Yes, one second.
That being void, on the 5th of August and 6th of August 2019, it is my submission that the two provisos applicable to Jammu and Kashmir were very much have to be treated as being in force. Two is that I'll hand across a one-page timeline. The timeline of how the resolutions and amendments were executed on the 5th and 6th of August 2019 shows, Millards, that there is absolute legislative legerdemain, something which it boggles the imagination. I'll show your lordship that neither the Constitution of India nor the Constitution of Jammu and Kashmir are applied, and what is done is just by a sort of sleight of hand. It'll become. I don't want to.
How would you formulate the second point? The first we got the proclamation.
I'll just place that before your lordship. But what I'm saying basically is
conceptualize it so we can just.
The point is, Millards, that the CO 273, which comes to be issued on 6th August, is in a sense applied in anticipation. A bill is presented by. I'm only on the Reorganization Act now. The bill for reorganization is presented by the President, tabled in the Rajya Sabha, passed by Rajya Sabha on the 5th of August, then tabled in Lok Sabha on 6th of August, and simultaneously with the recommendation of Lok Sabha to the President to issue CO 273. But simultaneously, even before 273 has been issued, Lok Sabha passes a bill which is purportedly passed by the Rajya Sabha the previous day. I'll just make good the proposition. I'm just outlining it. So what happens ultimately?
Justice said, what is the proposition? Then they tailored and managed the time in a manner, everything occurred within this 2 days' time. But we wanted to know what is that you're saying?
The point is that the provisos which are in place and the explanations, the two explanations, which are in Article 3, the two explanations were not applicable in Jammu and Kashmir because the 18th Amendment was never extended to Jammu and Kashmir. So the explanation which said that it's a union territory, the argument is that we can interchange states and union territories under Article 3 because of the two explanations which were introduced by the 18th Amendment. That was not applicable to Jammu and Kashmir on the 5th of August. So as far as Jammu and Kashmir is concerned on the 5th of August, it was only a state. Any changes under Article 3 could only be state to state. But I'll come to it. I'm just formulating the points. I'll hand across this. Now, dehors this aspect. My submission is that part 1, that is Articles 1, 2, 3, and 4, have to be read conjointly. And when you read them conjointly, no power can be found in Article 3 to convert a state into a union territory, notwithstanding the two explanations which are added by the 18th Amendment. Four.
One second. Yeah.
4 or 5, because I might lose track because it's all oral.
It's 4,
Is that if two interpretations were possible as far as Article 3 is concerned, then that reading should be preferred, which would be in keeping with the principles of federalism, the principles of democracy, the principles of the representation of the people of a state, and which would keep Article 3 out of conflict with Article 368. That reading should be preferred, and not a reading where Article 3 is allowed to ride roughshod, coach and horses through Article 368 without any of the safeguards introduced in 368. And this, Lord, I'll show your lordships, not just from the constitutional reading, but from the history of the article, Article 3 and Article 3, 4, that is 1 to 4, but 3, 4, and Article 368, and the view taken by your lordships in certain judgments, as well as Dr. Ambedkar's speech on Article 304, which was 368. That there has to be a harmonious construction between these articles, where that article 3 and 4, which allow an amendment to the constitution, but by a simple majority in parliament, can't impinge on those amendments which have the effect of either which attract the proviso to 368 or which in any case require a special majority by their very nature.
Will you be referring
So
to the text of the constitution for developing an argument? How should we now go about it? We made your 4 points. We made a note of the 4 points.
No, there is a little more here. So these are the broad issues. There might be some finer points. So let me just start straight away with, and I'm going to try to be brief, but I just want to preface it by saying that since I had confined myself to this subject, several of Mr. Kapil Sibal, Dr. Dhawan, etc., all touched on Article 3, but they made it clear that they're leaving it to me to argue this.
So let's see Article 3 first.
So I'll ask for some latitude from your lordship on time because of this. And I believe that the Reorganization Act, apart from 370, is very, very important for the people of Jammu and Kashmir. And also that if this interpretation of Article 3 were to be upheld by your lordships, then this is the thin end of the wedge for democracy and federalism in the country as a whole. Because any party in power at the center, if it also happens to be the party in power in a given state, can just convert that state by a simple majority in the state legislature, and a simple majority in parliament can convert the state into a union territory. This is a proposition of a course of action.
Let's see Article 3 now.
Which is broad. I'll come back to Article 3 in a moment. First, I'll go see the same
certainly
sequence. So first, para C2 of the presidential proclamation.
Where did you get that?
In volume 3, page 92 of the document, volume 3 of the documents. Page 92. Lordship, this is expressly under challenge in at least 4 of the petitions. And Mr. Raju Ramchandran's written submissions open with this also. So if we come to C straight away, Now, therefore, I hereby proclaim, I make the following incidental and consequential provisions which appear to me to be necessary or desirable for giving effect to the objects of this proclamation, namely, I'll come straight to two, the operation of the following provisions of the Constitution and of the state constitution is hereby suspended, namely, so much of the first proviso to Article 3 of the Constitution as relates to the reference by the President to the legislature of the state and the second proviso to that article. And then so much of clause 2 of Article 151, etc. But I'm concerned with this part in particular. So much of the first proviso to Article 3 of the Constitution as relates to the reference by the President to the legislature of the state and the second proviso to that article. This is now referring to the Constitution as extended to Jammu and Kashmir, because there are two provisos in Article 3 which were introduced by the 1954 presidential order.
Just one thing, Mr. C. Singh, the word used over here is suspended.
I'm sorry?
The word used over here is suspended.
Suspended, that's right.
It's not.
No, suspended. Now, we are talking about a presidential proclamation where the Constitution has not been able to be worked on the report that the President has presumably got from the governor, etc. And therefore, there's a presidential proclamation under 356.
No, I specifically drew your attention to this because you said that if we, while referring to the fourth argument of yours, the fourth contention of yours, you use the phrase that in case this is, there is possibility of misuse.
By suspending and then changing the nature of the state.
Please continue the argument.
The suspension becomes like an obliteration. If you suspend a requirement to consult the people of the state and then change that state into a union territory, that suspension it's an obliteration virtually. It doesn't. It might not make any difference whether we call it a suspension or
Mr. Singh, are you approaching it from the perspective of Article 356, that the power under Article 356 cannot be used to achieve these ends, such as the suspension? I mean, how are you further exploring the point?
Yeah, unless this was in furtherance of the object of 356 and it pertained to a body or authority of the state. Here, the suspension is of a constitutional provision which deals with consultation with the representative body of the state, which is the legislature of the state, the legislative assembly of the state. Now, this can't have even the remotest nexus with an Article 356 object to suspend consultation with the legislature of a state, or even, I'm now arguing against myself, or even the substitute for that legislature, which is Parliament, to suspend that consultation altogether. Can't have any nexus with the object of 356. 356 is for the purpose of, because the Constitution hasn't been working in that state, or the state isn't able to be governed as per the Constitution, and therefore there's a temporary suspension. And your Lord, I don't want to go into repeat arguments on 357.
The argument on your side has been that 356 is for the purpose of restoring democracy, not for abrogating. That was the argument.
That's right. And this, unless the union were to tell your lordship when they start their arguments, whenever they do, unless the union is to tell your lordship that yes, it was an object of Article 356 to change Jammu and Kashmir from a state to a union territory, they can never justify this as having any nexus with the object of 356.
Therefore, there are,
356 for a
Mr.
moment.
Singh, there are two distinct arguments therefore. One, whether the power under Article 3 can at all be utilized to convert a state into a union territory. That's one.
That I'll come to
And
subsequently.
the second, whether this power was correctly utilized or constitutionally exercised at a time when Article 356 was in operation. Does Article 356
Yes.
empower the union to do this?
That's right. But
There are
this
two
is just-
different areas which we would like to hear from you
I'm
very
very
briefly.
grateful to my Lord the Chief Justice, but this is one step before that. I'm saying that if you read, it says, make such incidental and consequential provisions as appear to the President to be necessary or desirable for giving effect to the objects of the proclamation, including provisions for suspending in whole or in part the operations of any provisions of this Constitution relating to any body or authority of the state. So my argument here is, one, such the para C2 can never even remotely be for giving effect to the objects of the proclamation. On 18th of December or 19th of December 2018, the object of the proclamation was not for changing the status of Jammu and Kashmir. And if it were, then it's a fraud on the Constitution. It's an absolute fraud on the Constitution if you admit that this had a nexus with your object on 18th of December.
In fact, to stretch your argument could be that the object of any proclamation under Article 356 can only be to ensure that the government of the state is carried on in accordance with the provisions of the Constitution.
As a stepping stone to restore full democracy in that state. I bow to your Lordship. I couldn't have put that better, very neatly. And I am very happy to adopt that line as my own. Now, in this behalf, if your Lordship will state away, I'll rather than take your Lordships into Bomai, in my Lord's, the Honorable Chief Justice's judgment in opinion in Krishna Kumar Singh, if my Lords are kind enough just to see that what is the judicial scrutiny required on a proclamation, presidential proclamation, volume 21 of the case law compilation.
Page?
At PDF 61, PDF 60, I'm sorry, because your Lordships have.
Which volume, Mr. Singh?
Volume 21, PDF 60, paras 55 and 56. Your Lordships have set out.
This is 7 judges, right?
Yeah, my Lord's judgment was 7 judges, and your Lordships have just extracted a very apposite portion from Bomai.
Page 60. Page 60.
Which page?
PDF 60 in volume 21 of the case law compilation. Your Lordships have it?
This one.
Look at the foot of that page, placetum G, just one line above placetum G, elucidating the approach of the court when a proclamation under 356 is questioned. Justice Jeevan Reddy held in Bomai case, para 373, whenever a proclamation under 356 is questioned, the court will no doubt start with the presumption that it was validly issued. But it will not and it should not hesitate to interfere if the invalidity or unconstitutionality of the proclamation is clearly made out. Refusal to interfere in such a case would amount to abdication of the duty cast upon the court, Supreme Court and High Court by the Constitution. The standard of judicial review was formulated in the following observations, Bomai case, para 374, and the truth or correctness of materials cannot be questioned by the court, nor will it go into the adequacy of the material. It will also not substitute its opinion for that of the President. Even if some of the material on which the action is taken is found to be irrelevant, the court would still not interfere so long as there is some relevant material sustaining the action. The ground of mala fides takes in inter alia situations where the proclamation is found to be a clear case of abuse of power or what is sometimes called fraud on power, cases where this power is invoked for achieving oblique ends. I'm confining myself to C2. I'm not, others before me have argued on the larger issue, but since I'm on the State Reorganization Act alone, I'm just keeping it as narrow as possible. C2, I submit, is clearly beyond the purview of the 356, and except for revealing the underlying intention of that proclamation, it does nothing more. C2. Now, then Rameshwar Prasad, a constitutional Chief Justice Sabharwal, then speaking for the bench in Rameshwar Prasad, at volume 3, PDF 96, if my lords are kind enough to come to that. Actually, PDF 95.
But, Mr. Singh, is the conversion of the state into a union territory, is it severable from the abrogation of 370 itself?
Yes, yes, it is. It is. The two are completely separate. Here, what has happened is that are relying on Article 3. They have by passing a simple law, simple parliamentary law under Article 3, a State Reorganization Act was passed. And
so your argument on the conversion of J&K into the two UTs, that would really survive irrespective of the decision on the abrogation of 370.
My submission starts with that this is completely independent of the abrogation. Whether J&K was from day one completely under the Constitution of India with no commas and full stops taken out of it, whether it was under 370 as applied to J&K, with any permutation.
Even if you were to exercise this power according to you in relation to any Indian state,
that's right,
this would be unconstitutional.
That's right.
Irrespective of the special considerations which apply to J&K in relation to 370.
Yes, yes, and irrespective of the proviso also, the scheme of Part 1 and read with Article 368, and I'll show you, Lordship, it completely precludes such an exercise. Also, when I come to the history, your Lordship will find that all right from the 1919 Government of India Act, 1935 Government of India Act, the precursors to Articles 3, 4, and 368, and then the Constituent Assembly debates, and then what came about. This was never the state, the powers given to the Crown initially, to the Governor General in 1919, to the Crown in 1935, and to the Parliament in 1950, were powers meant to mediate when a minority, perhaps in a state, made out a justifiable case for greater self-representation. Suppose there's a linguistic minority in a state, but they have a distinct area, like Haryana was in Punjab, or Himachal was with merger of princely states. The idea, or let us say there's certain other reasons where there are people who can't get a majority in that state assembly to accept, but they make out a case for greater autonomy, greater representation, for full statehood. Parliament under Article 3 and 4 acts as a mediator. Because
how are the UTs born in
yes,
the Republic?
I'll come to that.
I think in my judgment in NCT 2, I've dealt with the whole history of how the UTs were created.
You have. But
and were the UTs, in other words, was there a peculiar constitutional history attached to the creation of UTs?
Yes.
And does that category remain frozen now?
In fact, that category has moved consistently towards full statehood. By the 4th of August 2019, there were only
the origin of the creation of UTs.
Yes, but look, may I?
We'll have to then, because that your argument will have to explore in this way. What is the history surrounding the creation of union territories under the Indian Constitution? Yes. 2, does that category then remain a sort of frozen category in the sense that You can convert a UT into a state, but you can't do the reverse process. That's the
right.
second point.
And that is historically, that is what has happened. So by 4th of August 2019, there were 7 UTs left in India. And they were Delhi, Chandigarh, Delhi, Chandigarh, Daman and Diu, Dadra and Nagar Haveli, Puducherry, Lakshadweep and Andaman. All other UTs were gradually, once they could become viable units, the moment an area could become a viable unit as a state, it was converted into a state.
But what do we find? I mean, how are the UTs created?
Yes. So, look, can I just then give you a lot of the pages for this first argument, just so that
Yes, certainly, and then we can move to the next.
You're
on Rameshwar Prasad until I.
Rameshwar Prasad, look, the volume 3, page 95, PDF 95. Para 96. Here, my Lord, Justice Agarwal spoke for the bench. It was a unanimous verdict of the Constitution bench.
And what is the principle which Justice Agarwal has laid down there in para 90?
On the nature of the power under 356 and the nature of the scrutiny, he goes a step further beyond Lord Bomai. I'll only take your lordship very pointedly to the short 3 or 4 important paras. 96, Justice Agarwal says the power under Article 356(1) is an emergency power, but it is not an absolute power. Emergency means a situation which is not normal, a situation which calls for urgent remedial action. Article 356 confers a power to be exercised by the President in exceptional circumstances to discharge the obligation cast upon him by Article 355, which Mr. Nafde pointed to. It is a measure to protect and preserve the Constitution. The governor takes the oath prescribed by 159 to preserve, protect, and defend the Constitution and the laws to the best of his ability. The power under 356 is conditional, the condition being the formation of satisfaction of the President as contemplated by 356(1). My submission is that this applies equally to 356(2). And when the President is satisfied that certain measures need to be taken to fulfill the object of the proclamation, that also must meet the same test. Then look, para 97. There's an extract from Bomai in para 97 of the foot of that page. When the proclamation is challenged by making out a prima facie case with regard to its invalidity, the burden would be on the union government to satisfy that there exists material which showed that the government could not be carried on in accordance with the provisions of the Constitution. Since such material would be exclusively within the knowledge of the union government in view of the provisions of 106 of the Evidence Act, the burden of proving the existence of such material would be on the union government. And then, my lords, next para, overleaf, PDF 96, in para 98, just placidum C may be seen. If and when, this is Justice Jeevan Reddy's opinion in Bomai, if and when any action taken by the President in exercise of his functions is questioned in a court of law, it is for the Council of Ministers to justify the same, since the action or order of the President is presumed to have been taken in accordance with Article 74(1). And then 324, para 324, at the foot of that page of Bomai, in our respectful opinion, the above obligation cannot be evaded by seeking refuge under 74(2). The argument that the advice tendered to the President comprises material as well, and therefore calling upon the Union of India to disclose the material would amount to compelling the disclosure of the advice is, if we can say so respectfully, to indulge in sophistry. The material placed before the President by the Minister or Council of Ministers does not thereby become part of advice. Advice is what is based upon the said material. Material is not advice. And I won't trouble your lordships. And then para 100 is very important, overleaf at page 97. The above approach shows objectivity even in subjectivity. Constitutionalism or constitutional system of government abhors absolutism. It is premised on the rule of law in which subjective satisfaction is substituted by objectivity provided by the provisions of the Constitution itself. This line is clear also from Maru Ram. And look, then if your lordship would just come to PDF 120, PDF 120, paras 138 and 140, they're very short paras. PDF page 120 of the same volume, volume 3, paras 138 and 140. 138, clearly Bomai case expanded the scope of judicial review. True, the observations of Justice Reddy were made in the context of a situation where the incumbent chief minister is alleged to have lost the majority support or the confidence of the House, and not in the context of a situation arisen after a general election in respect whereof no opinion was expressed. But in our view, the principles of the scope of judicial review in such matters cannot be any different. And then para 140, thus it is open to the court in exercise of judicial review to examine the question whether the governor's report is based upon relevant material or not, whether it is made bona fide or not, and whether the facts have been duly verified or not. The absence of these factors resulted in the majority declaring the dissolution of the state legislatures of Karnataka and Nagaland as invalid. And lastly, my lords, Madhav Rao Scindia in volume 6, Volume 6, PDF 457. Para 111, I think, has been shown to your lordships by Mr. Nafde, perhaps. But para 113 at page 457 is very important. Volume 6, PDF 457. Para 113.
113.
By express injunction in Article 53(1) of the Constitution, the executive power vested in the President is directed to be exercised in accordance with the Constitution. That power is intended to be exercised in aid of and not to destroy constitutional institutions. Granting that power to recognize a ruler carries with it the power to withdraw the recognition of the ruler. The power must be exercised bona fide and in the larger interest of the people, consistently with the provisions of the Constitution to maintain the institution of rulership. Power may therefore be exercised in the course of and for recognizing another person as a successor to the ruler, having regard to the laws and customs governing the state. The President is not competent to recognize a person as a ruler who is not by the custom and law qualified to be a ruler. The President cannot obviously withdraw recognition of a ruler and recognize another, nor can he lawfully depart from laws and customs of the state to introduce a person as a ruler who is not by ties of blood, etc., etc. Now, the next page, the overleaf, 458, the fourth line, but unquestionably, the President is not invested with arbitrary authority to recognize a stranger as successor to the Gaddi or not to recognize any person at all as a successor. The power of the President is plainly coupled with a duty to maintain the constitutional institution, the constitutional provisions, the constitutional scheme, and the sanctity of solemn agreements entered into by the predecessor of the Union government, which are accepted, recognized, and incorporated in the Constitution. An order merely de-recognizing a ruler without providing for the continuation of the institution, which is an integral part of the constitutional scheme, is therefore plainly illegal. Because Madhav Rao was a judgment of a bench of 11 learned judges, and Justice J.C. Shah, His Lordship Justice J.C. Shah was speaking for 7 of himself and 6 other learned judges, for 7, the majority of 7. I think there were some concurring and some dissenting opinions. But I'm just placing this that these powers have to be exercised bona fide, and I don't see anything, certainly not in their counter, but there's no justification whatsoever for why these 2 provisos had to be suspended and what nexus that would have with the proclamation under 356. That's the first point. Now, may I just skip over the second point, that timeline? I'll come back to that. I've made just a one-pager where I set out that timeline. I can come back to that since the question fell from my lords about the background to union territories and how they came about and so on. And what is their status in the constitutional scheme? Yeah. So this is, if your lordships are kind enough to see what happened, I'll just summarize it and I'll take your lordship straight to the relevant provisions. 1905, Lord Curzon, my lords, split the province of Bengal. This was done unilaterally as a Governor General. That led to the partition or bifurcation of Bengal, led to a tremendous backlash against the British Raj. And there were huge protests, a lot of killings, etc., etc. And ultimately, in 1911, Lord Hardinge was compelled to rescind that move and restore Bengal as one province. Now, this experience led to a declaration by the British Parliament on 20th of August 1917 to devolve greater power on India and particularly on the provinces of India and the representatives of the people in those provinces. And this, your lordships will find, the declaration by Parliament led to the 1919 Act, the Government of India Act 1919, which specifically provided for the original precursor to Article 3. So the 1919 Act, along with that declaration, your lordship will find, volume 18 of the documents, and it's that proclamation, that declaration is very important, Lords, and as also the preamble to the 1919 Act. Volume 18, page 14, PDF 14, is the declaration of 20th August 1917.
Volume 18, page.
Volume 18, PDF 14, is the declaration of 1917, 20th August 1917. It's very short. May I read it, please? The policy of His Majesty's government with the Government of India and complete accord.
Have you got it?
Page 14. I'm so sorry. Volume 18.
The Government of India Act 1919, right?
Yes.
You have section 3 there, 3.1.
Yes, but the declaration is at PDF 14. The declaration of 20th August 1917.
No, that's not at page 14.
Page 14 is the Government of India Act.
Volume 18 is PDF 14.
No.
That's 10849, which is the page you're getting.
10835.
Oh, 10835. Right.
Yes, I don't know why my PDF. Oh, there must have been an earlier version. I'm so sorry. 10835. Does anybody have the correct page?
53.
What page is it?
I had it at PDF 14 because that was what was given to us.
10835.
The declaration of
20th of August PDF.
Declaration of 20th August 1917.
the PDF.
It starts with the policy of His Majesty's government, with which the Government of India are in complete accord.
PDF page 14. Yes, it's there.
We all have it as PDF 14. I think that
Yes, 835, right? It's 10835.
10835. And on this side, we all seem to have it at PDF 14. I don't know, there's some mismatch. My lord, find it now?
Yes, just one thing.
Yes. This is from extracted, this entire book is here in this volume, which is the Working Constitution in India by S.M. Bose, the 1921 publication.
Yes.
The policy
Yeah,
of His
just one
Majesty's
second,
government, with which the government
Just one, Mr. 1 second.
Where's Prasanna? My Lord, Honorable Justice Suryakant finds it. don't have a problem with PDF 58 also by the section. Perfectly matched. There's some. I could hand up an iPad if for my lord. Your Lordship, 10835, the running page. The declaration of 20th August, the policy of His Majesty's government, with which the government of India are in complete accord, is that the increasing association of Indians in every branch of the administration and the gradual development of self-governing institutions with a view to the progressive realization of responsible government in India as an integral part of the British Empire. They have decided that substantial steps in this direction should be taken as soon as possible, and that it is of the highest importance as a preliminary to considering what these steps should be, that there should be a free and informal exchange of opinion between those in authority at home and in India. His Majesty's government have accordingly decided, with His Majesty's approval, that I should accept the Viceroy's invitation to proceed to India to discuss these matters with the Viceroy and the Government of India, to consider the Viceroy views and the views of local governments, and to receive with him the suggestions of representative bodies. I would add that progress in this policy can only be achieved by successive stages. The British government and the Government of India, on whom the responsibility lies for the welfare and advancement of the Indian peoples, must be judges of the time and measure of each advance, and they must be guided by the cooperation received from those upon whom
Mr. Singh, what is the relevance of this actually?
Then, Your Lordship, just see the preamble. The progress, when Your Lordship sees the particular section, the preamble then was based on this of the Act in 1919, was 5 pages down. If Your Lordship just scrolls down 5 pages to the Government of India Act. Now, the preamble to the Act specifically said the 1919 Act, whereas it is a declared policy of Parliament to provide for the increasing association. So, based on this same declaration, there was the
Were the
preamble,
union,
then
were
the
the UTs all were the UTs all a part of the Part C territories?
So I'm just coming to that provision then straight away. If Your Lordships, I have it at PDF page 58.
And before the Constitution came into force, where were these Part C territories comprised?
Yeah, so there were.
They were the Chief Commissioner's provinces.
Yes, that's right. So there were the governor's provinces became Part A states. The Governor General and then later the Governor. So Bombay Province, Madras Province, Calcutta, Fort William, etc., became the Part A states. The Indian states, which
became Part B.
Not all of them, there were 562 states, those which could be merged and made into viable states, because viability was the main crux here.
But J&K was also a Part B state.
That's right. So those which were viable as states, all Indian states which were viable either standing as they stood or by merger, became Part B states. Those which were
now, in the Government of India Act, what was the classification of the territories in the Government of India Act?
Yeah, that in the Government of India Act, there were governors' provinces, there were chief commissioners' provinces, and I'll just show that.
So we must look at what was the position in the Government of India Act.
That's right.
how that transformed into the constitution.
Yes.
So that will give us an idea of how the union territories were created.
Yes, and in fact, in the
The union
Constitution,
territories came into being. One thing is very clear, the union territories came into being with the 7th Amendment in
Seventh Amendment.
1956.
So in the Seventh
That
Amendment,
abrogated the distinction between Part A, Part B and Part C states and the Part D territories,
yes,
and then brought the entirety of India into the states and the union territories.
Union Territory. Now, so I'll just show you Lordship the progression. So if your Lordship sees here, please come straight away to PDF 58, which would be in the same volume. It's 10879 running page.
Page 58.
But your 58 won't match because 14 wasn't matching. Could your Lordship tell me what was your equivalent PDF for 14?
The difference is 14 pages actually.
14 pages, 14 more. So this 58 would be 72, perhaps around 72, 1087. 10879. It should be a PDF 72 if there's a difference of 14 pages.
How does it start?
Section 14 is on the top, Government of India, 10879 is the running page. The printed page number is 44 and it's PDF, we have PDF 58, all of us here.
PDF 72 is 10907.
109.
PDF 44.
Oh, it's 14 less then. So it should be 44, perhaps PDF 44. PDF 44 should work out. 43 or
You're referring to internal page 44. PDF is 58. Section 14 you're referring to.
Yes,
14, right?
we are getting PDF 58.
That is
internal page-
10879.
Yes.
That is page 44, I think.
No, that's page
Yeah,
44.
yeah,
PDF
yeah.
is page.
So your Lordship's PDF is matching the internal page number, I think.
No.
Page.
So now 15.1. Which page? But on, what I'm taking your Lordships to is the precursors to Article 3. But to answer the union territory aspect, in my written submission, your Lordship will find that.
So now we are at 10879 with a great effort. So let's focus on that. We don't lose this precious page.
So this is the precursor to Article 3 in the 1919 Act, Section 15.
Section 15.
Yes.
All right, let's see that.
And the marginal note is constitution of new provinces, etc., and the provisions as to backward track. The Governor General and Council may, now please note, after obtaining an expression of opinion from the local government and the local legislature affected. This is why I was reading that preamble and the declaration of the King, His Majesty. The Governor General may, after obtaining an expression of opinion from the local government and the local legislature affected, by notification with the sanction of His Majesty previously signified by the Secretary of State and Council, constitute a new governor's province or place part of a governor's province under the administration of a deputy governor to be appointed by the Governor General, and may in any such case apply with such modifications as appear necessary or desirable all or any of the provisions of the Principal Act or this Act relating to governor's provinces or provinces under a lieutenant governor or chief commissioner to any such new province or part of a province.
Therefore, that is the power to constitute a new governor's province.
Yeah.
Yes.
And then subsection 2 deals with backward tracks. We are not concerned with that. This was then carried forward in section 290 of the 1935 Act.
Where is that?
That your Lordship will find. Look, I'm sorry, in this, could your Lordship just read the footnote to this? Section 15, there's a footnote of the committee report, which is very important. This is in the whole thing of self-governance. The footnote is on the next page. For constituting, the committee have two observations to make on the working of this clause On the one hand, they do not think that any change in the boundaries of a province should be made without due consideration of the views of the Legislative Council of the province. On the other hand, they are of opinion that any clear request made by a majority of the members of a legislative council representing a distinctive racial or linguistic territorial unit for its constitution under this clause as a sub-province or a separate province should be taken as a prima facie case on the strength of which a commission of inquiry might be appointed by the Secretary of State, and that it should not be a bar to the appointment of such a commission of inquiry that the majority of the Legislative Council of the province in question is opposed to the request of the minority representing such a distinctive territorial unit.
Now, where is
This is that what I was saying about the arbiter, Parliament being an arbiter when there is within a
now,
state.
where is the Government of India Act, section 290?
290, your lordships will find in volume 6, my lords, of the document, PDF 113, and I trust, my lords, this time we'll all be on the same page, my lords. Volume 6,
Volume 6.
Page?
page 113, my lords. 290 is almost in the same form in which Article 3 came to be enacted by the Constituent Assembly.
What is the page?
Your lordships have page 113, my lords, PDF 113,
113.
113.
volume 6, my lords, document volume 6. Creation of new provinces and alteration of boundaries of provinces.
Which is the, and how are the provinces distributed under the Government of India Act, actually?
Section 5, my lords, of this.
Yeah. 5, refer to? What is the PDF page for page?
PDF page 18, I'm very grateful to Mr. Shankar.
18.
Yes, Proclamation of the Federation of India, PDF 18 of this same volume 6, minutes. Establishment of Federation and Accession of Indian States, Proclamation of Federation, it shall be lawful for His Majesty, may I read that? If an address in that behalf has been presented to him by each House of Parliament, and if the condition hereinafter mentioned is satisfied, to declare by proclamation that as they therein appointed, there shall be united in a federation under the Crown.
No, but it's kind of important because it says it shall comprise of the provinces, hereinafter called the governors' provinces, and the Indian states which have acceded or may thereafter accede to the federation. And in the federation so established, there shall be included the provinces hereinafter called the chief commissioners' provinces.
That's right. Then the conditions referred to is that states the rulers whereof will in accordance with the provisions contained in part 2 of the first schedule be entitled to choose not less than 52 members of Council of State, and the aggregate population whereof as ascertained in accordance with the said provisions amounts to at least 1/2 of the total population of the state so ascertained have acceded to the federation. Then the manner of accession is in section 6. And the footnote notes to section 5. It says section 5 was substituted as follows. This is not the after 15th August 1947. I think this was in 1948.
This is important.
Government of India Act was.
So with the Indian Independence Act, we got the governors' provinces, the chief commissioners' provinces, the Indian states in the manner hereinafter provided, and any other areas that may be with the consent of the Dominion included in that Dominion.
Yes, and this was not under the Indian Independence Act. This was an amendment to the Government of India Act 1935.
Right. Following the Indian Independence.
Following the Indian Independence Act, absolutely. Because till then it was only the British Parliament which could enact the law. After 15th August 1947, the amendments were made by the in the Dominion by the Dominion.
Now, were the chief commissioners' provinces is referred to in any schedule to the Government of India Acts or no?
Chief Commissioner Provinces, no, I think it's in the 1919 Act, but just check in the 1919. Just check it. Page?
Page 49.
Oh, of this very thing?
Oh, I'm very grateful. Part 4, the Chief Commissioner Provinces, correct. At PDF 49, my lord, have that? Section 94 onwards. My lord will find this, my lord, Honorable Justice Suryakant will find it
Yes.
PDF 49. my lord.
Yes. Good.
Part 4, the Chief Commissioner Provinces. The following shall be the Chief Commissioner Provinces, that is to say, the heretofore existing Chief Commissioner Provinces of British Baluchistan, Delhi, Ajmer, Merwar, Kurg, and the Andaman and Nicobar Islands, the area known as Pant Piploda, and such other Chief Commissioner Provinces as may be created under this Act. Aden shall cease to be a part of India. A Chief Commissioner Province shall be administered by the Governor General, acting to such extent as he thinks fit through a Chief Commissioner to be appointed by him in his discretion. Then British Baluchistan is set out in
So
95.
now from here we go to the Constitution. Would it be correct to say that when the Constitution was adopted on 26th of January 1950, the territories were comprised into Part A states, which comprised of the governor's provinces, the erstwhile governor's provinces. Part B states, which were the Indian states which had acceded to the dominion of India. Part C
No, only
states.
such of those which were viable.
Right, we're not now on the Jammu and Kashmir thing at all. We are now looking at the broad.
Yes.
So this argument is independent of the J&K issue.
Yes.
Part C states were the erstwhile chief commissioners' provinces.
Yes. And
Part D states were the other territories.
no, and Part C
Let's
state
look at
also had one more category.
Let's look at the Constitution as of 26th of January 1950, because that schedule will give us the distribution between what was Part A, what was Part B, Part C,
Yeah.
and Part D.
Just one qualification. I
That
was
whole
not,
the Part C states had the Raj Pramukh.
that's right.
I think Part B also had the Raj Pramukh. Part C had the Raj Pramukh. Part A had the governors.
That's right.
And that continued from 1950 to 1956.
That's right.
56, following the Fazal Ali Commission, everything is abrogated and you just have states and union territories.
That's right. But just one small qualification. Part C states also included Indian states which were not able to be merged into a viable unit. So, for instance, Himachal Pradesh was consisting of 30 Indian states, 30 small Indian states. But because the province of Punjab, the governor state of Punjab came almost to the edge of Shimla at that time, there were hill areas of Punjab, and they automatically went as a part A state. So Himachal Pradesh, with its 30 states acceding and merging into it, still was not viable. So it was a Part C state, though it was Indian states, but Part C. So there were several such cases of those which were not viable as independent statehood at that point in time. It became a Part C state. It became a union territory in 1956. Then in 1966, when Punjab demanded a Punjabi Suba, and there was a huge movement and agitation, etc., as a negotiation to give Punjab a linguistic state, Haryana was carved out, and the hill areas of Punjab were carved out and given to Himachal. It still continued temporarily as a UT, and in 1971 it was made into a full state.
Now, do we have the Constitution, just to complete the whole exercise?
Yes.
The Constitution as of 26 January 1950, where is that?
Yeah.
They can put it on the screen.
All right, they'll put it on the screen actually.
If your lordship, in the meantime, may I just very quickly take your lordship to my written submission, a very brief thing on how this transition took place, page 468 of my written submission.
So, Mr. C, you're saying at the time when Punjab, the division of Punjab took place, there were two union territories. Himachal Pradesh was carved out as a union.
And Chandigarh.
And Chandigarh was carved out.
Because of the.
Correct. There were two union
That's
territories
right.
which are carved out.
That's right. That's right. Absolutely, your lordships are right. In fact, this is all in my note, but even in the written submission. But the point here is, right from the 1919 Act, the progression has been consistently and continuously towards greater self-governance, and greater self-governance in the form of full statehood.
We are only on the, today, for that, the question is legality of that order in terms of Article 3.
That's right. That's right. So, but the context in which the reading that I would seek to persuade your lordships to adopt is one which would be consistent with that objective of greater self-governance. When we read Article 3 as opposed to Article 368, that greater self-governance and the move that, because keep in mind that barring these small, unviable or special status union territories, Delhi, Chandigarh, Andaman and Nicobar, Dadra and Nagar Haveli, etc. By 4th of August 2019, there were only 7 union territories left in India. And the 7 were Delhi, Chandigarh, Andaman and Nicobar, Dadra and Nagar Haveli, Daman and Diu, and Puducherry and Puducherry. These were the 7 union territories left. All others were merged or amalgamated.
Now see what they have put up on, is very interesting. Part A, this is on the date of the Constitution. Part A states are basically 9 states. Assam, Bihar, Bombay, Madhya Pradesh, Madras, Orissa, Punjab, United Provinces and West Bengal.
That's right.
Now let's see Part B, thoda sa scroll kar lijiye.
Part B.
We get this.
ये कहाँ से मिला आपको?
Part B states,
now Part B are Hyderabad,
Jammu and Kashmir, Madhya Bharat, Mysore, Patiala and the East Punjab states. That's the PEPSU, Patiala and East Punjab States Union, Rajasthan, Saurashtra, Travancore, Cochin and Vindhya Pradesh.
Right.
Then your lordship sees the territories of the state. The territory of each of the states in this part shall comprise the territory which immediately before the commencement of the constitution was comprised in the corresponding Indian state, and in the case of each of the states of Rajasthan and Saurashtra shall also comprise.
जम्मू एंड कश्मीर का टेरिटरी देख लेते हैं क्या है, थोड़ा सा ऊपर चलिए और जाइए ऊपर, थोड़ा नीचे, नहीं ऊपर ऊपर.
Now your lordships will see that some of those commissioners' provinces were merged into Part B states because they became viable. Pipoda.
वहीं पर. Ajmer, Bhopal, Bilaspur, Cooch Behar, Coorg, Delhi, Himachal Pradesh, Kutch, Manipur and Tripura.
Himachal Pradesh was at that time also?
Part C mein tha.
Was it not included in Punjab? It was later on included in Punjab.
And ऊपर जाइए थोड़ा सा.
Punjab was
now, if your lordships come to Part C state,
the second paragraph of each of these parts in the schedule describes what they were earlier. If your lordship sees Part A, Part B, Part C, they have explanations below the list. No, it's there. It's
yes.
Part of this.
If your lordship just goes below Part B, territories of states.
Below the list, these territories they have for each of the parts. Now, the second explanation there describes where they came from.
Beneath each of the lists, the territories are given, and that shows how different units were merged into them even on the beginning of the Constitution.
Right.
I have also got a table in my
and Part D only comprised of Andaman and Nicobar.
Andaman and Nicobar, which was a chief commissioner's province in the 1935 Act. But that was carved out separately.
So Ladakh is a UT, and the change of status from a state to a UT of Jammu and Kashmir.
Yes,
both aspects.
Both. First of all, just the conversion of a state into a union territory, I submit, is only if at all it could be done. I submit it violates the basic structures. It can't even be done under Article 368. But if at all it could be done only under Article 368 because it clearly impinges on at least 6 or 7 provisions in the proviso. So it would require both the special majority and ratification by more than the legislatures of more than 50% of the states to convert a state into a union territory, and I'll make good that submission.
Therefore, I refer to two different things. Carving, the change of status is one, and suppose Jammu and Kashmir assembly status was maintained and only UT was carved out, then what would be argued?
Even so, Manoj, the submission really is that for both for Ladakh and for Jammu and Kashmir, Manoj, the exercise which has been done is one which is clearly beyond the purview of Article 3. It was not permissible under Article 3 at all, even if it had been rightly done. I'll show from the timeline that it's actually not even done as per Article 3. But assuming it were rightly done under Article 3, this is not the scope of the power of Article 3. When I take your lordships through the provisions of the Constitution, your lordship will see Article 295, Article 294, etc. A state comes with property or lands, property, consolidated fund, rights, contracts, right to raise money. It has absolutely sacrosanct powers under Article 73, read with Article 162. The executive powers, the legislative powers.
Your 1 hour, how long would you now take?
Look, I'll try to be as brief as possible. I think it will take about an hour or so.
No. 1 hour, no, Mrs.
Look,
Can't be 1 hour. Can't be.
I'll tell you also, this is what I'm arguing is something nobody else has argued, but the main thing here is we are saying that regardless of what
is the point of this chart then?
Look, independent.
You're supposed to have a kind of a arguing discussion.
Look,
in 1 hour you take 2 hours, then this schedule means nothing.
Look, I acceded to your lordship wishes and I confined myself from day one. I adopted other people's arguments. I'm not touching on 370 at all. I'm saying that and if at any stage your lordship feel that I'm going beyond the purview of there are the 4 or 5 points which I outlined at the beginning.
You've made your 4 points, but you have made your 4 points now, and your argument really is this. That look, insofar as they're twofold, you cannot convert an area which is comprised in a state into a union territory. Now we have seen the history of the creation of the union territories.
Yes.
Because when you create a union territory, we've also, people who have preceded you, they have said that, look, the whole essence of a state is democracy. You have a legislature, you have elections, you have converted it into a union territory which has no legislature, which has no elections over the past 4 years. Therefore, that's one aspect. The second aspect,
and the large bulk
the second
of
aspect
the state
of your submission
without a legislature altogether.
The second aspect of your submission is that you can't use the Article 356 power to suspend the 2 provisos to Article 3 and then use that to complete the process of conversion of these states into. So these are the 2 key areas, really. I think we can give you another 10 minutes.
I'll go with, look, I won't be able to do it in 10 minutes. And I think your lordship will perhaps accept my submission.
Actually, Mr. Singh, everybody has argued this point also before. Just that.
Look, I will not repeat a single argument that anybody has made. I'll take your lordship very
3 to 3:15. We'll give you 15 minutes, I think.
Look, I'll go as quickly as I can.
Minutes and that's it. Now,
I don't think I'll be able to do that. No, then
Mr. Singh, advisor.
I'll go very quickly. I will not take extra time on anything. I'll just go point wise and place the relevant pages.
Tomorrow they have to start arguing. Between all of you, we decide now, we'll give you a little more time, but it will cut into somebody else's time. So who that person is, you please decide for yourself.
No, I think that that may not be proper in this case.
Delimitation, for instance, we are not concerned with delimitation here. Delimitation is not an issue in these petitions. So we have to now, the delimitation argument.
No, I'm not arguing on delimitation.
No, that's what we are trying to say is that at lunch, you reorganize the time between yourselves because delimitation will not arise at all in this.
I think your lordship may need to give us a little bit of time tomorrow, a little bit of time.
No. We'll conclude today of all this ideas. Mr. Singh, one request. I'll tell you why we were trying to put a little time limit now. With all the hard work which has been done by your side, I think, we have reached a point of mental saturation, not fatigue. Mental saturation where we are now, there are questions to be posed to the other side and answers to be required from the other side.
Yeah.
So in that sense, conscious as we are that if we are putting an end to your argument a little earlier, on the reorganization, we'll bear that in mind so that when they respond and it comes to the rejoinder, we'll give you a little more time in the rejoinder, because then you will have to really deal with what their defense is.
Yes.
Because broadly, reorganization was argued before you also, though you put it in a different way. We have seen the provisions now. We would now like to be in a situation where we conclude this part and we sort of, we have questions to the other, to be posed to the other side. We have to demand answers from them. And we're now at a point of the matter where, you want now to move on. That's the only thing. I mean, it shouldn't be misconstrued. Why are we sort of curbing arguments?
No, I'm conscious of the anxiety of the court.
6, 7 council lifetime. It is such a matter which has such no ramifications. So
Yes.
just some kindness from your lordship.
Yes.
And leave you.
So
Yes, Mr. Singh.
I'll just summarize the point on the union territory
Yes.
aspect. I have, in fact, in my written submission, I've got a detailed note on it. I'll just flag that to your lordship. Let me just summarize it, in 3 or 4 sentences.
Yes.
That's all. So basically, the point is this: that the history of Articles 3 and 4, emanating from the 1919 and 1935 Government of India Acts.
Just one second, Mr. The history of Articles 3 and 4 emanating from the
1919 and 1935 Government of India Acts shows that the powers to alter boundaries, change names, etc., was always used to increase self-representation and democratic self-government.
under
There
Article
was no case of retrogression.
was used to
Increase democratic self-government and self-representation, and there was no case of retrogression. Secondly, my lords,
just one second. Yes.
these powers were always exercised after due democratic consultation with the people of the concerned region, state, or territory. And this, your lordship will find in my written submissions. My written submissions were that PDF 445 of
We
the
won't say with the people of the territory, we'll say with the legislative representatives of the territory.
people of the territory through their representatives, which is why I showed your lordships the section 15. Which is why I showed your lordship the footnote to section 15, the committee report which led to section 15 of the 1919 Act. Lordship recall that the committee report and what they said about the consultation. Similarly, the 1935 Act, and then, my lords, and in my written submission, which is that so these points are made out. I'm just summarizing it. At page 445 of the combined written submissions is my written submission, PDF 445. From pages 464 to 472, I deal with this history and progression of union territories. 464 to 472. I'm not even taking your lordship through it. I'm just identifying it for your lordship. In particularly, my lords, paras 41 to 43, a note may be made of this. I've set out a chart of how various territories changed from Part C state to union territory, Part C state to union territory to full statehood, etc., etc. And that's why I was, the way I would sum it up is that when your lordships see Schedule 1 to the Constitution and the section on union territories, my lords will find that today there are only 6. I mean, take away Jammu and Kashmir, because even Dadra and Nagar Haveli and Daman and Diu have been merged into one in 2020. They've been merged into, they've been made into one unit. Even though because there are 4 small parts, 800 kilometers this side, 400 kilometers that side, etc., etc. Because between Daman and Diu, it's an 800 kilometer driving distance. I mean, not flying, but if you drive around the down the run of Kutch, etc. So, so these small non-viable territories have remained, which are not viable as states, have remained as union territories. None other. All have gone in one direction. So this your lordship will find in my note. I'll say no more about this. No, that's done. Now coming to the next point, lords, is that 3 and 4 have to be read. First of all, I said that 3 and 4 have to be read as part of part 1. Now, part 1 is very important because your lordships have been showed Article 1 and 2. Article 1 says India shall be a union of states. Article 1 was amended by the 7th Amendment when union territories came to be introduced. But Article 1.1 and 1.2 were not amended. Union territories were added in 1.3. In 1.3b. So even while amending in the 7th Amendment, India, that is Bharat, shall be a union of states. The territory, the states and the territories thereof shall be as specified in the first schedule. These were not amended when union territories came into being in the 7th Amendment. What is added is 3. The territory of India shall comprise A, the territories of the states, B, the union territories specified in the first schedule, and C, such other territories. But the basic concept of India, that is Bharat, shall be a union of states, was maintained. Article 2 was maintained as it is. Admission or establishment of new states. Parliament may, by law, admit into the union or establish new states on such terms and conditions as it thinks fit. Article 3 was not amended till the 18th Amendment, when those two explanations were inserted. Now the explanation has become the tail which is wagging the dog. And from that it is sought to be contended by the union that because the explanation says for certain portions the state shall include union territory, therefore any permutation and combination is now available to Parliament under Article 3. Now, keeping aside the fact that the two explanations were never extended to Jammu and Kashmir. The two explanations which were introduced by the 18th Amendment were never applied to Jammu and Kashmir.
Just one second.
I'll come back to
made
that,
that
keeping that aside for the moment. So this fiction that you can convert a state into a union territory was, by the Constitution of India, never applied to Jammu and Kashmir. But keeping that aside for a moment, because I'll come to that on that timeline issue. Now, please see the enormity of it if you accept this argument for a moment of converting states into union territories as a whole, and for the whole of the country, including Jammu and Kashmir, because we are saying that it's an integral part of India. Please see Article 294 and 295 may just be seen. These particular articles I want to show because my Lord, the Honorable Chief Justice wanted to know how were these provinces dealt with by the Constitution of India. So under 294, those properties of His Majesty's government, which were used for the dominion, became part of the union properties. Please see 294A. All property and assets which immediately before such commencement were vested in His Majesty for the purposes of the government of the Dominion of India, and all property and assets which immediately before such commencement were vested in His Majesty for the purpose of the government of each governor's province shall vest respectively in the union and the corresponding state. So properties which were for the Dominion vested in the Union of India, properties which were for a governor's state, which were being used for a governor's state, vested in the corresponding state, Punjab, Bombay state, Madras state, etc., etc. The properties pertaining to that state vested in the state by constitution. Similarly, all rights and liabilities, etc., again, respectively in B. Then 295, succession to properties, assets, and in other cases. Now, please see 2. Sub 2, I'm just taking a look. This is now dealing with the Indian state. Subject to the aforesaid, the government of each state specified in Part B of the first schedule shall, as from the commencement of this constitution, be the successor of the government of the corresponding Indian state as regards all property and assets and all rights and liabilities and obligations that are arising out of any contract or otherwise, other than those referred to in clause 1.
Yes.
So those properties became the Part B states properties. Part C and Part D were not defined here because the union had control of them. The union had control of Part C and Part D, so they remained in a sort of a silo. Because what really happened is Part C and Part D and union territories are really a stepping stone. It's a silo kept as sort of a holding pen, so to speak, till you can get full statehood. The holding pen, the silo in which you're kept safe and secure under the benign umbrella of the Union of India. It's really for that. It was never intended.
And Mr. Singh, anyway, Mr.
Now,
Nafde,
I'll just make this point.
Mr. Nafde, in the concluding part of his submissions, has given us a whole list of what the impact on the constitutional structure is. And we have made note of that. 1, he said Ladakh has no representation in the Rajya Sabha. 2, Rajya Sabha, all of the 4 seats go to J&K. 3, Lok Sabha, Article 81C, all UTs can have a maximum of 20 seats. Article 81(2), other states' seats depend on population. J&K has no proportional representation in the Lok Sabha. Presidential election, Article 54 and 55. Yes. J&K, no MLA for presidential election. The Reorganization of Act of 2019 gives the same rights as Puducherry. 279A, no representation on the GST Council, and High Court judges, no views of the CMRT.
I'll just add a few more. Now I won't take your lordship to the sections. I wanted to show this section just to show how property and rights devolved. Now I'll just mention a few words. Under Article 266 provides for the consolidated fund of the union and a separate consolidated fund of the states. 261 and 2. 283(2) provides for the custody of the consolidated fund of the state and the manner of withdrawal from that custody. 289 exempts the property and income of a state from union taxation. Once 283 162. Now this is very important. 162 says, subject to the provisions of this constitution, the executive powers of the state shall vest in the state in respect of list 2 and list 3. List 3 only if Parliament makes a specific provision by a law to exercise executive powers in respect of some particular provision of list 3, executive powers now I'm talking about, only then to that extent the state will yield executive powers to the union. Otherwise, all executive powers in the state on subjects of list 2 and list 3 are exercised by the state. And this is not subject to a law made by parliament. This is subject to the provisions of this constitution. The reason it is subject is like 256, 257 are a qualifier on 162. 256, 257 is where the union, for purposes of defense, etc., can encroach to some extent on the powers of the state. 73 is the concomitant executive powers of the union. 73 has a, please just see that, 73 has a specific provision which says the union shall not exercise any of the powers of the state. 73, subject to the provisions of this constitution, again, not by law, the executive power of the union shall extend to matters with respect to which parliament has the power to make laws and to the exercise of such rights, authority and jurisdiction.
Proviso, the proviso.
Now, proviso, provided that the executive power referred to in subclause A shall not, save as expressly provided in this constitution or in any law made by parliament, extend in any state to matters with respect to which the legislature of the state has also powers to make law.
The proviso to 73 and the proviso to 162 are mirror images.
Mirror images, mirror images.
Because
So,
the executive power of the state also extends to laws, to concurrent field subjects,
that's right.
and including any law made by parliament in the concurrent list, unless parliament expressly reserves the power to the union government.
That's right. That's right. Absolutely right. Then verse 293 further clarifies that the executive power of the state extends to domestic borrowings against the consolidated fund of the state. So there's a specific constitutional power of that. 298 extends the executive power of the state to carrying on trade or business, acquiring properties, etc.
All right, Mr. Singh.
And then 246 and the lists.
Yes.
Now by a simple expedient of a simple ordinary majority under Article 3, all these constitutional rights, many of which are directly part of the basic structure of the Constitution, are wiped out. So, look, the theory is,
Point is taken, Mr. Singh.
no, this has been dealt with by your lordship, fortunately, and I want to just place that. Following, if your lordships are kind enough just to see the judgment of a constitutional bench in Shankari. Where's that one? All displayed. So, if my lords are kind enough to take up Shankari Prasad, I'd ask the learned court master to keep it ready. It's on the screen. This is AR 1951 SC 458, and His Lordship Justice Patanjali Shastri, speaking for the bench, spoke of harmonious interpretation of the different modes of amendment under the Constitution.
Para?
If your lordships come to para 6, on the first point it was submitted. And then overleaf, let's come to the last about 8 lines of para 6. Various methods of constitutional amendment. Do your lordships find that? Various methods of constitutional amendment have been adopted in written constitutions, such as by referendum, by a special convention, by legislation under a special procedure, and so on. But which of these methods the framers of the Indian Constitution have adopted must be ascertained from the relevant provisions of the Constitution itself, without any leaning based on a priori grounds or the analogy of other constitutions in favor of one method in preference to another. We accordingly turn to the provisions dealing with constitutional amendments. Now, the Constitution provides for 3 classes of amendments of its provisions. First, those that can be effected by a bare majority, such as that required for the passing of any ordinary law. The amendments contemplated in Articles 4, 169 and 240 fall within this class, and they are specifically excluded from the purview of Article 368. Secondly, those that can be effected by a special majority as laid down in Article 368. All constitutional amendments other than those referred to above come within this category and must be effected by a majority of the total membership of each house, as well as by a majority of not less than 2/3 of the members of that house present and voting. And thirdly, those that require, in addition to the special majority above mentioned, ratification by resolutions passed by not less than 1/2 of the states specified in Part A and Part B of the first schedule, This class comprises amendments that seek to make any change in the provisions referred to in the proviso to Article 368. This is what my learned friend Mr. Nafde highlighted, some of those provisions which directly fall within A to E of the proviso. It will be seen that the power of effecting the first class of amendments is explicitly conferred on Parliament, that is to say the two houses of Parliament and the President. This would lead one to suppose, in the absence of a clear indication to the contrary, that the power of effecting the other two classes of amendments has also been conferred on the same body, Parliament, for the requirement of a different majority, which is merely procedural, can itself be no reason of entrusting the power to a different body and examine it. Because the argument here was being made that a constitutional amendment can't be made by Parliament, it has to go back to a constituent assembly. So that was a negative. Now, Milord, this was followed in Sajjan Singh. This Shankari dealt with the First Amendment, and Sajjan Singh dealt with the 17th Amendment, that is AR 1965 SC 845. And para 7, 8, please just see the first 4 lines of para 7, Sajjan Singh. In our opinion, my lord, have that? In our opinion, the two parts of Article 368 must, on a reasonable construction, be harmonized with each other in the sense that the scope and effect of either of them should not be allowed to be unduly reduced or enlarged. Then in para 8, milords, about line 7 from the top, in other words, in construing both the parts of Article 368, the rule of harmonious construction requires that if the direct effect of the amendment of fundamental rights is to make a substantial inroad on the High Court's powers under Article 226, it would become necessary to consider whether the proviso would cover such a case or not. If the effect of the amendment made in the fundamental rights on the powers of the High Courts prescribed by 226 is indirect, incidental, or is otherwise of an insignificant order, it may be that the proviso will not apply. In other words, you have to harmonize these two provisions, and if it is substantially falling within, impinging on those A to E of the proviso, then you have to follow the greater. Then come to para 30, milords, of this.
So we'll see that, Mr. Singh. This is well settled. We'll have a look at it.
Very well. I only want to point out para 30, milords, because para 30 deals with Article 4 directly. So I would request your lordship, para 30. Incidentally, we may also refer to the fact that the constitution makers had taken the precaution to indicate that some amendments should not be treated as amendments of the constitution for the purpose of Article 368. Take, for instance, Article 4.2, which deals with law made by virtue of Article 4.1. Article 4.2 provides that no such law shall be deemed to be an amendment of the constitution for the purposes of Article 368. Similarly, Article 169.3 provides that any law in respect of the amendment of the existing legislative apparatus by the abolition or creation of legislative councils in states shall not be deemed to be an amendment of the Constitution for the purposes of 368. In other words, laws falling within the purview of Articles 4.2 and 169.3 need not be passed subject to the restrictions imposed by Article 368, even though in effect they may amount to the amendment of the relevant provisions of the Constitution. So, they say that these provisions have to be read harmoniously, as in Shankari, and they are exempted. But the exemption can't mean that you completely efface if you are falling within 368, to efface, milords, the provisions there. Now, as it happens, milords, this is, if your lordship just goes very quickly, milords, to the Constituent Assembly debates for a moment, I just want to show your lordship Dr. Ambedkar on this, his speech on this very same provision, and why this ascending power of amendment, and how it has to, each one has to apply only in their limited sphere. So if your lordship sees volume 8 of the documents, and at page 881, this is Dr. Ambedkar's speech, begins at the previous page 880, dealing with Article 304, the draft Article 304, which is 368. Now, para 4, milords, on page 881. Now let me turn to the provision of our Constitution. What is it that we propose to do with regard to the amendment of our Constitution? We propose to divide the various articles of the Constitution into 3 categories. In one category, we have placed certain articles which would be open to amendment by Parliament by a simple majority. That fact, unfortunately, has not been noticed by reason of the fact that mention of this matter has not been made in Article 304, but in different other articles of the Constitution. Let me refer to some of them. Take, for instance, Articles 2 and 3, which deal with the states. So far as the creation of new states is concerned, or the reconstitution of existing states is concerned, this is a matter which can be done by Parliament by a simple majority. Similarly, take, for example, Article 148A, which deals with the upper chambers in the provinces. Parliament has been given perfect freedom to either abolish the upper chambers or to create new second chambers in provinces which do not now have them by a simple majority. Now take Article 213, which deals with the states in Part 2. With regard to the constitution of the states, the draft constitution also leaves the making of the constitution of states in Part 2 and their modification to Parliament.
Nothing much turns on this really.
No, the harmonious reading, if your lordship.
That's well settled. Why do we have to read the speech for that?
I'm sorry, Milord?
We don't have to read the speech to have harmonious construction.
No, I'm only on this, what Justice Patanjali Shastri, the formulation that he made in Shankari, actually.
The three provisions, bare majority, two-thirds majority, and two-thirds majority with ratification. Those are the three separate provisions.
Just see page 882 for a moment, or just flag it. Your lordship may just flag it. The third para in 82, now what is it we do? And the next para below that, after the interjection by the president, yes, now we have no doubt put certain articles in a third category where for the purposes of amendment, the mechanism is somewhat different or double. It requires two-thirds majority plus
ratification.
I shall explain why we think that in case of certain articles, it is desirable to adopt this procedure. If members of the House who are interested in this matter are to examine the articles that have been put under the proviso, they will find that they refer not merely to the center, but to the relations between the center and the provinces. We cannot forget the fact that while we have in a large number of cases invaded provincial autonomy, we still intend and have as a matter of fact seen to it that the federal structure of the Constitution remains fundamentally unaltered. We have by our laws given certain rights to provinces and reserved certain rights to the center. We have distributed legislative authority, we have distributed executive authority, and we have distributed administrative authority. Obviously, to say that even those articles of the Constitution which pertain to the administrative, legislative, and other powers. State 22883. It's very important because it specifically deals with 73 and 162, the articles which were 60 and 142. And it says that these cannot be changed. This ratio, this balance cannot be changed except by a special majority coupled with ratification by more than half the states. So that may be just noted. Now in Mangal Singh, this is reiterated, and I'll just give your lordship the pages now. Mangal Singh, your lordships will find at volume 6, PDF 386, para 6.
Yes.
And in State of Himachal Pradesh versus Union of India, volume 14, PDF 776.
Volume number?
14.
Volume 14, PDF 776, para 93. And this is very important, Lord, if I can just draw your lordship's attention to it. Specifically, the Supreme Court held, my lords, in this judgment, what is not permissible under, my lords, Article 3 and 4. If your lordships are kind enough just to turn to volume 14, page 776. Para 93, we find, my lord, have that? Volume 14, page 776, para 93. we find that under the provisions of Article 3 of the Constitution, Parliament has the power to form a new state by separation of territory from any state, or by uniting two or more states or parts of states, or by uniting any territory to a part of any state, increase the area of any state, diminish the area of any state, alter the boundaries of any state, and alter the name of any state. But under Article 3, Parliament cannot take away the powers of the state executive or the state legislature in respect of matters enumerated in List 2 of the 7th schedule to the Constitution. This has been made clear in the speech of Dr. Ambedkar in the Constituent Assembly, quoted in paragraph 52 of the decision of this court in Kuldeep Nair versus Union of India. Relevant portion from the speech is quoted. The basic principle of federalism is that legislative and executive authority is partitioned between the center and the states, not by any law to be made by the center, but by the Constitution itself. This is what the Constitution does. The states under our Constitution are in no way dependent upon the center for their legislative or executive authority. The center and the states are co-equal in this matter. And then, my lords, your lordships have been shown Berubari in volume 13, page 492. Various paras, but my lord may just note the paras in Berubari, volume 13. It starts at page 492, paras 36, 38, 44, and especially 46 are very important. Then, my lords, R.C. Podial, etc., your lordships have been shown those. I won't. So,
Just reeling of judgments.
I'm so sorry.
Just reeling of the judgments and giving para numbers, doesn't it form a part of your synopsis? If it forms a part of your synopsis, we will give a consideration to it.
Well,
Otherwise, what's happening is you're depriving your other colleagues of a right to.
because of in the context of that this could only have been done under 368(2).
Understood the problem.
That is the essence. Now, the last point, then I will close, is what the second point I had raised, but my lord, the Honorable Chief Justice wanted me to address on union territories to start with. So this is with regard to the timeline and how there was no power at all to table or enact this law at all in the manner in which it has been done. The reorganization. Please just take this timeline.
Exactly.
Parliament, how Parliament passes it, does it fall within?
No,
If
if there was, the point here is not, the point here is if it is, if CO 273 was not there and the Constitution of Jammu and Kashmir and the Constitution of India as applicable in Jammu and Kashmir was in force, this could not have been tabled at all.
Trying to say there was not inadequate debate, how the Parliament was conducted, this would be a difficult area to get. We understood the other propositions, but now to say,
No,
well,
but-
they did it in this much time.
No, if
Done it not this much time, but this much time.
No, let me put, I'm sorry, it's my fault, no, I have not made the point clear. If Article 3 says, for instance, that it will not be introduced unless the president has done ABC, and it is apparent that the president has not done ABC, but ABC gets done on the subsequent date. It's not there on that date. Rajya Sabha passes a bill which it is not competent to pass at all, not competent to even table or consider under the terms of the Constitution. Then that's all I'm trying to point out. Please just take a look at this. It's a very short, just a timeline of 5 entries of what happened on 5th and 6th. This is all from available in the, and I've given the PDF pages of each of the documents.
Just give us, what are the dates? You can tell us the dates. Just give us the dates.
Your Lordship,
We'll not be able to handle these sheets now. We've got everything in the soft form. I mean, these sheets will just fly around the place.
It just
You
gives
might as
PDF
well-
pages. Very well.
This will be a part of our record.
Now, on 5th August 2019, CO 272 is issued by the President, which adds subclause D to clause 4 of Article 370, substituting the Legislative Assembly.
Heading,
That might save your lordships a little time if I can just hand
No,
it
yeah.
out.
Not part of your synopsis, that's what I'm asking.
it must be part of your submissions, right?
It's part of your submission.
The written submission.
No, this timeline is not set out. This is all, it's in the COs and what is in volume
It's
3.
like a supplementary submission now being sought.
You don't want to,
It's not
otherwise it
submission.
will become
Exactly what you
impossible.
said.
It's not submission. I can take your lordships directly to the documents. It's not a,
So just tell us now quickly the dates so that we
yes.
can wrap up now.
so when CO 272 is issued by the president. This merely adds a subclause D, which substitutes the legislative assembly for the constituent assembly of the state. On the same day, this is at volume 3, page 101.
To us,
Let me close with that. We'll go through this.
Now, on the same day, the second entry, the Lok Sabha, on a reference from the president, this is the phraseology, passes a resolution to accept the J&K reorganization bill presented to it by the president for its views. Now, this is at volume 3, page 104. I'll tell your Lordship the importance of this.
We'll have a look at it. Yes.
Let me just make the point, Lord.
What's the point of doing this? See, you please tell us if we will not go beyond 4 o'clock. You ask your colleagues whether it's fair to them or not. That's all I'm saying.
May I just summarize the point in a few sentences?
1 hour was taken. We've given you 1 hour, 45 minutes. Still you feel something more has to be done.
50 minutes.
This is not fair, honestly.
If your Lordships have felt that I have repeated myself in any way or not
Everybody has to ration
summarize
time.
it.
Everybody has to ration time, you know.
We have given you time. We have summarized it. At some stage, all good things must come to an end. The arguments must come to an end. Let us have the next council now to address this.
Let me just make the point in 2 sentences, Lord.
Yeah.
The point here is that under the 2 explanations did not apply to Jammu and Kashmir until CO 273 got passed on the following day, and it was only recommended simultaneously along with the Rajya Sabha passing the Lok Sabha passing the J&K Reorganization Act. This is not permissible because until then the Constitution of India as applicable to Jammu and Kashmir applied. The explanations were not there. Union territories were not in Article 3 as it applied to Jammu and Kashmir. So I'm saying that what was tabled and what was passed by the Rajya Sabha purportedly on 5th of August was something clearly contrary to Article 3 itself. So if they are founding their case on Article 3, I submit that is ultra virus. That's the point.
Thank you.
Thank you, Mr. Singh.